Good afternoon. The Senate Transportation Committee will come to order. Hold on one moment.
You have to sign up for my newsletter. Sign up for my newsletter.
All right. Clerk, would you open the roll, please?
Mr. Chair, you have a quorum?
All right. Thank you very much. Looks like we have the House members here. We were worried a little bit that they were going to be caught up in the process. I'd like to start out, if I could, here with our chairman from the House Transportation Committee, Delegate Austin. Would you like to kick us off here? I think you have two bills, and one of which, House Bill 2423, is identical to my bill, Senate Bill 981. Is there anything you want to add to?
No, sir, I do not.
That?
Mr. Chairman, I think the bill's in good posture with your bill.
All right, very good. Could I have a motion on that, please?
Report.
We have a motion and a second to report. Open the roll, please.
Ayes 15, no zero.
Ayes 15, no zero. The bill reports. All right, and the second one that we have is about towing recovery operators and attorneys' fees and costs, House Bill 2392.
Yes, sir, Mr.
Prepared
Chairman.
to present on that?
I am, Mr. Chairman.
All right, go right ahead.
House Bill 2392, as you stated, allows a towing operator whose services are rendered by any local or state law enforcement officer or other government official to recover reasonable attorney's fees if the court finds that the towing and recovery operator is entitled to a monetary award for an underlying claim. So, Mr. Chairman, if, for instance, on the interstate where we have our trip program and they go out and there's an accident in these heavy trucks, it requires a lot of cleanup and a lot of time spent to open the highway back up. And sometimes, and oftentimes, the recipient of the bill challenges it and they don't want to pay it. And right now there's no mechanism by which for them to recover their attorney's fees if the judge so allows. The language says they may allow. So we worked with Dale Bennett and the Truckers Association and others who agree that this language is acceptable and is a mechanism to move forward with, and all parties are in agreement. Thank you, Mr.
Thank you very, very much, Mr. Chairman. And do we have any questions from the committee?
Mr. Chairman.
Senator Servo.
Thank you, Mr. Chairman. I have a question with the patron. So would this attorney's fees remedy apply only to commercial vehicles, or would it also apply to sort of people that were rear-ended on the Beltway or something?
It's currently anyone who has a claim who does not pay it. They can petition the court to pay attorney's fees if they go to court to recover their cost.
Okay.
Mr. Chairman.
Okay, thanks.
All right. Senator Sproul.
So what he was saying, sir, since he's a lawyer, he wants to know will he get paid.
I'm sure he always gets paid. He's a very good lawyer.
There we go. Any other questions from the committee? Anyone in the audience wish to speak in favor of the bill?
Mr. Chairman, members of the committee, Greg Habib from Gentry Lock here on behalf of the Virginia Professional Tow Operators. We're the public safety tow operators, so we're doing those tows directed by law enforcement, by localities, by state police. We obviously support this bill. We appreciate Mr. Bennett and the truckers working with us when we converted the shall award attorney's fees to a may award attorney's fees. That puts it in the court's discretion. To Senator Servo's question, I'll just make one point. One, it only applies to public safety towing. It also only applies to those cases where a claim is brought. You don't see claims brought against consumers or individuals in these contexts because those vehicles retain value such that the consumer usually gets their vehicle back and pays for the storage. The problem we have with the public safety towing on the interstate is frequently the cleanup and the storage of the trailer are more valuable than, or the cleanup is more expensive than the value of the trailer, so they just leave it behind. And so we have to go pursue a claim. It's really almost never brought against an individual. The intention is to get to those claims.
Mr. Chairman, a question.
Senator Servo.
Thank you, Mr. Chairman. Question, Mr. Habib. So, and I think I know the answer to this, but assuming for the sake of argument that there was a consumer who was in a bad collision and their car got towed and they had insurance, and then the insurance company got in some fight and didn't pay, am I right that any attorney's fees assessed by the court would be payable by the insurance policy?
Yeah, so, Mr. Chairman, members of the committee, under Virginia law and under the application of the Bureau of Insurance, any policy written in Virginia has to have collision coverage that includes towing, cleanup, and storage. So yes, the insurance company in Virginia would cover any claim. Now that's part of the problem because these out-of-state trucking companies, sometimes their Bureau of Insurance doesn't require their policy to have that same collision provision that ours does. But yes, if you brought a claim and the judge awards you attorney's fees, it would be covered by the policy.
Mr. Chairman.
Senator Servo.
So is it fair to say then that the only consumers that would be affected by this attorney fee remedy would be people who don't have insurance on their car, which we passed another bill requiring everybody to have insurance? So they'd already be in violation of the law, right?
That's right. Mr. Chairman, members of the committee, if Senator Ruff's bill gets signed into law by the governor, there will be no more uninsured drivers. So everybody will have that collision coverage, yes.
Okay, thanks.
And it's my understanding, Delegate Habib, that about 25% of these situations where people are towed is that the bill isn't paid and there has to be some kind of legal action or just forfeiture of the property.
That's right, Mr. Chairman, members of the committee, which then passes those costs off to others. Again, especially it's out-of-state drivers who aren't paying, that raises prices for in-state drivers.
Oh, okay,
Mr.
thank
Chairman.
Senator Obenshain.
Just following up on Senator Servill's question. So, all right, if I'm a driver, I'm driving my 2000 Toyota Tundra with 200,000 miles on it and I've decided not to have any collision coverage on it. And I'm in a wreck that is my fault or nobody's fault. And my truck gets towed and I've got a problem, paying the towing. The tower can get a judgment against me.
So, Mr. Chairman, members of the committee, the existing law, the tower could already get a judgment against you.
But with attorney's fees.
If it's a public safety tow under the 3 referenced statutes, they could request attorney's fees. It would be up to the court to award those or not. The question becomes, who should bear the loss there? The driver who chose not to be uninsured or the trucking company that was responding to a public safety tow request?
But, Mr. Chairman, Greg,
Senator
we have the American rule here. Where litigants bear their own costs in most settings, their own attorney's fees. And this will carve out an exception to the American rule.
Yeah, Mr. Chairman, members of the committee, you know how much Senator Obenshain and I love this exact conversation because this is what we do for a living. So the American rule is that litigants bear their own attorney's fees except when a statute says otherwise or when a contract says otherwise. Very frequently in the code, we have already awarded attorney's fees or set a situation where a party can recover attorney's fees because of the nature of the claim. The reason these claims should be an exception to the American rule is because in these cases, we are acting as an agent of the state, but the state isn't collecting the fee for us. We're having to do it. And so by stepping into the shoes of the state to collect and then having to bear the loss, it should be an exception.
Senator Obenshain.
Since you're acting as an agent of the state, wouldn't it be more fair for the state to pay it than the person who didn't call?
Mr. Chairman, members of the committee, that was the first version of the bill that we shopped around the General Assembly, which nobody was interested in carrying, and so this is where we landed. I would love for the Senate Finance Committee and House Appropriations to set aside a fund to pay unpaid towing. I'll ask the Vice Chairman of House Appropriations when we leave here if he's interested in. He said he's not interested in doing that. I'm sorry.
There you go. All right. Any other questions from the committee?
You're not going to carry it for us?
Anyone here else to speak in favor? Anyone here to speak in opposition? Anything you want to add, Mr. Chairman?
We
Sure, Mr. Chairman, thank you, Ken.
Have a motion to report. Do we have a second? We have a motion and a second to report. Open the roll, please. Oh, excuse me. I've got
Ayes 15, no zero.
Ayes 15, no zero. The bill reports.
Thank you,
2
Mr.
for
Chairman.
2.
Thank you, members.
There you go. All right, we'll move now to the list that we have. We have Delegate Bourne. You have your bill?
Thank you, Mr. Chair.
All right, Delegate Bourne, tell us what you've got here for us today.
Yes, sir. House Bill 2104 is quite simple in nature, but I think it'll have a tremendous impact on the safety of our students and our communities. It simply allows localities to set up school crossing zones up to 700 feet from the school. Right now, current law sets that at 600 feet, but this bill would extend it to 600 or 750 feet. And so that's the bill in a nutshell. Be happy to answer any questions.
And in certain circumstances, it's been indicated by law enforcement and other government folks that that would be a better place to put.
Well, yes, sir, Mr. Chair, and I would say also that it doesn't change any of the requirements of studying or planning that have to go on. It simply allows that school crossing area to move further out from the school, so you can start to decrease the speed limit going up to a school and provide a little bit more safety for the students that are walking to and from school.
All right, very good. Any questions from the committee?
Question.
Senator Favola?
Thank you. I guess this is a question to the patron or maybe general counsel. I just want to clarify, it doesn't matter who owns those streets, correct? Whether it's state or locally owned, this is a school zone.
Correct.
Okay, and
Correct.
that's
And
clarity.
Mr. Chair, Senator Favola, the version before you is very different than the introduced version, and we simply, the bill, as you'll see, crosses out 600 and puts in 750. That is the only change to this section of the code.
Okay, and there's no substitute here. This was done in the House.
Correct.
All right, Senator Cosgrove.
Thank you. Delegate, the financial impact statement says there is no financial impact, but all the signs are going to have to be changed or moved, correct?
Mr. Chair, I would say to Senator Cosgrove, they would have to be changed if the locality chose to extend their school zone. If they don't, there's no reason to expend money to move the signs.
So it's permissive and not directive.
Mr. Chair, I would say to the Senator, he's correct, it is permissive.
Thank you.
Other questions from the committee? Anyone here in the audience to speak in favor of the bill? Anyone to speak here in opposition to the bill?
Will report.
Second.
I have a motion and a second to report. Would you open the roll, please?
Ayes 15, no zero.
Ayes 15, no zero. The bill reports.
Mr. Chair, thank you and the committee members for your time and
All
attention.
right, very good. Next on our list, Delegate Rasool. Are you? Yeah, there he is. All right.
Good afternoon, Mr. Chairman, members of the committee. House Bill 2191.
Turn your attention to 2191 from Delegate Rasool. Let me just find it here. And please go ahead.
Thank you, Mr. Chair, members of the committee. House Bill 2191 is a permissive bill to help local law enforcement that allows for the locality to have their code enforcement to assist in the removal of immobile vehicles. Currently, these immobile vehicles, which are sometimes left unattended on a public highway or other means, would require certain law enforcement to organize the removal thereof. But in some localities, they could use the additional support, and this allows for the civil code enforcement to be able to do so. This has the support of the Chiefs of Police and Police Benevolent Association.
All right. Any questions from committee members? Anyone in the audience wish to speak in favor of the bill? Anyone in the audience wish to speak in opposition to the bill?
Mr. Chairman, question.
Senator Cosgrove.
I think, Delegate, basically, locality civil code enforcement division, are they trained in how the proper method of towing and disposal of these types of vehicles?
Thank you, Mr. Chairman, Senator Cosgrove. This is simply notification that would enable them to be able to request that it be removed. So, for example, right now, law enforcement is able to make the phone call and actually organize that. Code enforcement wouldn't actually be moving the vehicle, but would be able to put in the same request if the locality wanted them to.
Okay.
All right.
Mr. Chair. Mr. Chair.
Yes, Senator Rouse.
Question for the patron. If the vehicle is properly tagged and under DMV standards, properly tagged and allowed on a public street, I'm thinking of those people who live in apartments or townhomes and they park on the public street and perhaps, especially in Hampton Roads area, we have some of our men and women in the military. If they got a flat tire or they're working on their car, but it's properly tagged. Will this allow the civil department, because the neighbor may say, hey, you can't, change your brake pass or stuff on this property? Would this allow for the civil department to tow the vehicle if it's properly tagged?
Thank you, Mr. Chairman, and Senator Rouse, all-star basketball player. There's a difference in the code between abandoned vehicles, and sometimes there's an abandoned vehicle, and this is an immobile vehicle section, so it's an excellent question. But this is just truly when you've got an immobile vehicle, or, for example, if it's been left unattended for 10 days or more, then that's when this would apply.
Okay. Is there any effort to determine, Delegate Rasool, that the car is indeed abandoned and the person just isn't in a 2-week vacation but parked legally? Would there be any effort made to determine where the person might be?
Thank you, Mr. Chairman. This actually ordinance does not apply, for example, to any motor vehicles or trailers or anything that is on private property without the consent, for example, of the private property owner. So if it's an immobile vehicle that is broken down on the side of the street, and normally law enforcement would order its removal, the locality would have the ability to be able to do that. And so normally if you've got an abandoned vehicle, which is in a separate section of the code, that would be handled differently.
Okay, thank you. Senator Cosgrove.
Thanks, Mr. Chairman, ladies and gentlemen of the committee. That this really is a pretty simple addition. Basically, the locality's Civil Code Enforcement Division isn't doing the towing. They're not physically moving anything. They are just able to call for a tow for an abandoned vehicle, the same as law enforcement would be able to do. So, I mean, it's not that difficult.
So the same standard would apply as to when you make that determination, because usually that's going to be made by local code folks anyway, and then police called. So it's the same finder of fact, I guess, would be just initiating it. All right.
Mr. Chair.
Senator Rouse.
Since Delegate Rasool, Mr. Chair, gave us a hard time in the House versus Senate basketball game, I just wanted to make him sweat a little bit.
I can appreciate that, Mr. Chairman.
It's the only way I get a chance to get back at him.
That's right.
As well. But no, thank you, Mr. Chair, Delegate Rasool. My last question is so if someone goes on a month vacation, perhaps they're taking care of their elderly mother and they leave their car on the street, parked outside of their house on a public street. I just want to make sure that it's not considered abandoned, that the car, for all intents and purposes, looks like it's able and it's mobile, able to be moved, that there will be some type of, I guess, effort to ensure that the car isn't abandoned. I think that was what Senator Chairman Marston was getting at.
If I might, Delegate Rasool, I think the issue was resolved with the idea that nothing really changes with the determination. It's just who makes the determination. And so it's just going to be the code folks who would make the determination anyway. It just doesn't require them to go through the police to do it. They can make the direct call to the tower and allow police officers to do what police officers need to do, which is protect public safety.
Thank you, Mr. Chairman.
All right.
Can I get a 2-minute warning as well?
Here it is. It's coming. It's coming.
Okay.
No more questions.
All right. We operate by motion. What do we have here? We have a motion and a second to report. Would you open the roll, please?
Ayes 15, no zero.
Ayes 15, no zero. The bill reports.
Thank you, Mr. Chairman, members
The
of the
House
committee.
is on a roll here.
And I owe him a free shot in the next game.
Yeah. And just remember, when you've been here as long as some of us, you will eventually be non-factors in the game. And all right, next on the list, we have Delegate Wyatt.
Good afternoon, Mr. Chairman and committee members. House Bill 1649 is a very simple bill. As we know, dealing with private property, a trespass towing, several years there has been no increase, and all their charges and fees are set in code. This only allows a fuel surcharge of up to $30 for each private property or trespass tow that is removed from private property.
Thank you. Just to remind the committee and those in the audience is that we worked diligently this year to try to come up with a long-term solution to this by dealing with some of the folks in Planning District 8 and the trespass towing industry, and were ultimately unable to come to a determination as to how we should move forward, other than to PBI the bill, which we did, and provide for a letter to the Secretary to create a study group to look at the long-term solution. What the delegate is putting forth right now is a temporary solution, which was one of the things we considered for 1 year, because we know the difficulty that there has been with regards to inflation. And I think Mr. Benka can tell us how long it's been since they've had a raise. But at any rate, we will, make a determination about this independently, because if this bill passes or this bill fails, it makes no difference. The study will continue because we do need a long-term solution. We need so many solutions in the towing industry. It is a long Christmas list.
Mr. Chairman.
Senator Cosgrove.
Thanks. I just want to say that we're filling out our reimbursement forms here on the Senate floor, either yesterday or today. If you will notice, our reimbursement for mileage went from 55 cents to 0.665 cents. So basically, cost of fuel is going up. I mean, it's got to be handled somehow.
Yep, so noted. And
Mr. Chairman.
with that, you have a question. Senator Favola.
I just think we should put some context on this, though. The localities do have the authority right now to raise the towing rates, and it is an authority that has been exercised by our localities for quite some time. So what this is, it's an override, basically, of the authority of local government, and it's in effect for a year. And I would expect that it establishes a floor. Am I correct in that?
Well,
or is it the maximum for a year? I would like an answer to that.
Up to $30. So yes, it's an increase, no different than state employees have received 5% for the last 4 years. This is an increase from the hookup fee of up to $30 or 20% from what their maximum rate they can charge for a hookup now. And as the chairman said, it's only good for 1 year. It's a sunset, because I know we are both working on legislation with these folks.
And one of the problems here is that I don't believe the towing board, at least in Arlington County, has met in quite a while, and some of that is a responsibility of the towing industry, who hasn't shown up to to any of the meetings, and we don't get a quorum. It's just one of the many, many things that need to be straightened out. The issue here in this bill, as I understand it, is to provide temporary release due to extraordinary circumstances, and I would certainly have to stick with what I agreed with the Planning District 8, but it is up to the committee to make their determinations. Any other questions from the
Mr. Chairman.
committee? Senator Spruill.
Most of us don't live in Planning District 8 in Northern Virginia. So after that 1 year sunset clause, then what happens then after 1 year? Then what happens?
Senator Spruill, if I could answer that question, hopefully our group will have met and we will have a long-term solution for a bill next year that will take us beyond just this attempt at a temporary fix.
Mr. Chairman, second question to you then.
Senator Spruill.
So hopefully, you said hopefully, what happens if the group meets and you can't come to a conclusion? Then what happens?
Hold on. Could we suspend for just one moment while I confer with my... Okay. Thank you. Since Delegate Wyatt, since this issue, began with...
Mr. Chairman, wait a
planning-
minute. Mr. Chairman, you haven't answered my question.
I'm sorry, Senator Spruill, what was that?
You acting lawyer too. You acting like a lawyer. My question is that after that 1 year sunset, you said they hoping they can work it out and things will be okay. So my question that after 1 year sunset, you come back, you're trying to work it out, and it has not been worked out. Then what happens?
Well, that's what we're about to solve right now with my next question to Delegate Wyatt, who would need to perhaps accept an amendment to restrict this to Planning District 8, which I think was the original intent here, and not to do this statewide. I don't.
I think the towers, and they would like to speak to the committee. They've come from great distances to come share their story today, but I think what I'm being told is the Central Richmond District as well as
Planning
District 8.
16.
Well,
And
Mr.
okay.
Chair.
I have not finished my question. Mr.
Okay,
Chairman.
Senator Spruill.
So you got one question that y'all are ducking. You want to answer that question. The second question then, what about the rest of the state who does not live in District 8? I'm never going to move to Northern Virginia. I'm never going to run for governor. So what about Tidewater? I am statewide. I understand that.
Let's have, why don't we have council answer, this question as to where the bill resides at this point. Is it statewide, or is it just districts 8 and 16?
Mr. Chairman, it's statewide.
Statewide. Okay.
That's right.
And Mr. Chairman, I will talk to you. When we originally were contacted to carry this bill, I talked to towers across the entire Commonwealth, Virginia Beach, Newport News, as well as Northern Virginia and the Roanoke area. So, yes, there is concern and a need for this to expand statewide.
Okay, so the bill is statewide.
Mr.
Okay.
Chair,
Senator McClellan.
was your bill statewide or only limited to Planning District 8?
I believe mine was statewide.
Okay.
But the primary negotiations were done where the problem was, which is in Planning District 8, but we were unable to come up with a solution to that. So this remains a statewide.
Mr. Chairman.
Mr. Chair,
Senator McClellan.
I would note that the cost of living in Planning District 8 is significantly higher, and wages are significantly higher in Planning District 8 than in the rest of the state. And I would suggest if you want a bill to come out of this committee, you might want to limit it.
Mr. Chair.
Senator Cosgrove.
Mr. Chairman, gasoline has become much more expensive in Arlington, and it's become much more expensive in Wytheville. Basically, it's much more expensive in Hampton Roads, and it's much more expensive in Winchester. So basically, yeah, wages are higher, cost of living is higher in Northern Virginia, but the gasoline prices these folks are having to pay has risen throughout the state. So we can limit it to a planning district if you want, but the rest of the state is having the same impact.
But, Mr. Chairman, excuse me.
Well,
Senator McClellan.
Go ahead.
I'll defer to Senator.
Senator Favola.
Again, my understanding is that localities have the authority to apply this surcharge now. Is that correct?
Yes, and Planning District 8 has executed that authority because they are lower at $135 connection compared to the entire state of Virginia.
Right, and I
so if you get if it's a private property tow in Virginia Beach or Central Virginia or Roanoke, the initial hookup fee here is $150, but Planning District 8 has reduced theirs to $135.
And that, I guess, that has been the problem. So I'm just trying to for clarity's sake, for my colleagues, I think some of the issues related to the additional cost of either fuel or hookup have been addressed in other parts of the state.
I believe that's, Mr. Benka, would you step forward?
would.
And
Thank you, Mr.
I believe
Chairman.
some of that has been addressed in other parts of the state have a higher a fee, do they not?
There is no fuel surcharge in code right now. So the localities can only charge what is allowed in state code. And right now, you can only charge a hookup fee and then 2 instances of the holiday, weekend, and evening. That's all we can charge besides storage. So you cannot do a fuel surcharge. I appreciate what you said about the study, and I'm really looking forward to doing that. We have not received a raise in 3 years. During that time frame, 2020, state employees got a 5% increase, 2021, 5%, 5%, and in 2023, y'all are going to give them a 7%. In that same time, we've gotten nothing, absolutely nothing. So we need this surcharge to be an intermediary between now and the time that we can do the study. I would say that Arlington County, who's questioned this issue, has given an employee pay raise every year for the past 4 years. I would also note that Arlington's going to get up and oppose this, but they've given themselves, their board of supervisors, gave themselves a 35% pay raise not too long ago. They were making $57,000. Now they're going to make $77,000. So in the meantime, we're potentially going to get nothing. So we're asking that we get this fee surcharge for 1 year until we do your study, which we're really looking forward to, and then we'll move forward. In terms of the statewide, it really has to be statewide. We would be open, I guess, to some planning districts, but you're talking hundreds and hundreds of families that have not received a pay increase in 3 years. And if this doesn't pass, it'll be 4 years.
But the solution we were working on, Mr.
That's the long
Benka,
term.
was a long-term solution,
Yes,
but
sir.
it really was probably only going to impact the place where the charges were much lower.
Depending on how.
Depending on how it worked out, but that was our focus, was trying to solve that problem.
Yes, sir.
Mr. Chairman,
Okay.
question
Thank
to
you.
the gentleman.
Senator Spruill.
To your question,
Yes, sir.
let's take the study. And let's say when the study come back, there's not into your favor. And you were saying we haven't had this in 3 or 4 years, the raise in 3 or 4 years. Give us this raise. Give us for 1 year.
Yes.
So we're going to give you this raise for 1 year, and then we do the study. The study come back is not in your favor. Then what you going to come back and ask us for?
Well, I'll be honest with you, Senator Spruill. Chairman Marsden has been wonderful to work with. Chairman Marsden has been wonderful to work with. And
Chairman
so-
Lawson from North Virginia. I'm not concerned about that.
Yeah, no. I can't speak to what ifs, but I know that as long as Chairman Marsden and others are a part of this study, we'll work out something that can work. But to your point, if we don't get this $30 surcharge this year, it will be 4 years since we've gotten a raise. And we're the only industry in Virginia, that is set in code. There's no other way for us to get a fee increase. So that's all we're asking for, and I appreciate the question.
Mr. Chair.
Thank you. Senator McClellan.
Okay, so as I understand, because I hear two different things. I hear you want this surcharge because you want employees to have a raise. And I hear this is a fuel surcharge to pay for fuel. And when I read the bill, it is a fuel surcharge.
I'm sorry.
So the policy we are being asked to vote on is to allow you a fuel surcharge to pay for an increase in the price of fuel. However, fuel in Northern Virginia, as someone who travels up and down 95 a lot and is about to do it again more, fuel in Richmond and Central Virginia is less than fuel in Northern Virginia. Fuel in Northern Virginia has an added sales tax to pay for transportation projects in Northern Virginia that is not in Central Virginia.
Right.
So if the public policy behind this bill is allow us a surcharge because the cost of fuel has gone up, that's one thing. And we need to factor in the fact that fuel prices vary around the state. If it's to give employees of tow trucking companies more wages, that's not what this bill says. And you're asking us to have consumers pay more for salaries under the guise of paying for fuel. So which is it?
Senator, we're in a difficult position. I mean, every time we come, for 20 years I've been representing the towing industry. Every 3 years we have to come back, and every 3 years we have to horse trade. There's no other industry that has to come in here and literally beg to get a little bit of an increase. Direct rate is set, but you are correct. It's a surcharge. The price of fuel has gone up absolutely dramatically. Could some of that also offset a little bit of employee wages? Potentially.
Yeah.
I will let some of the folks talk right here. You've got a lot of folks that are local towers to Richmond that will want to opine on that surcharge.
Senator McClellan, if I might, this gets at the difficulties we had in arriving at a solution here, because the big reason for the study is we have no data, and you've reflected right there the fact that the data is going to be different from different parts of the state. And so it gets very difficult to pluck a number and to say that this is it, because it applies differently in different parts of the Commonwealth, and that has been the conundrum that we've been in trying to solve this, which is why we need the time to again study this. And this amendment came from the House because they wanted to do something about the cost to the towing industry of continuing to do what they do in high inflationary times, and reflecting this as a fuel charge is probably a little bit simplistic. There are a whole lot of things that have gone up in cost, and it's unfortunate that it had to be put in those simplistic terms, but essentially I think we understand what's going on here, in terms of what their needs are. But we get back to, that's the reason why we PBI'd my bill and requested the study, so that we could get the data that we've been unable to get from the towing industry, to be able to make a decision that incorporates the kind of complexities that Senator McClellan, that you envision here, which you are absolutely correct. This is not a simple thing. What they're trying to do here is provide some simple temporary relief, and that's a decision that the panel, that the committee here will have to make as to whether to go with that.
Mr. Chairman, just before
Senator Cosgrove.
Thank you. We need to correct something that's going on here. Basically, for those of us that sign the front of the paycheck and not the back of the paycheck, it's the bottom line. Basically, if their bottom line is being impacted by higher operating costs, they are not going to be able to provide more wages or higher wages to their employees. They're not going to be able to buy capital equipment. They're not going to be able to maintain their vehicles. It all comes down to the bottom line. Whether you call it a fuel surcharge or you call it something else, the costs have gone up exponentially. And that's what these folks have to deal with.
That is correct. Unfortunately, the bill, talks about this in terms of fuel only. But I think we understand the larger issue. Any other questions from the committee? All right. Would you like to have your gentleman?
I will just add one other thing. Localities do have the data. They have the number immediately when someone picks up a trespass or private property tow. They usually contact law enforcement, because the first instinct is for the individual to call local law enforcement and let them know that my car is missing, not there, so they can let them know it's been towed, this company has it, so they can contact their yard. So they do have the numbers, the volume in a locality for private property towing.
Delegate White, that's just part of the data that's needed. But you're correct. There's the volume thing is known, but there are things like a tow in Scott County could be a 20-30 mile tow. A tow in Arlington could be a 3-4 mile tow, and you could do many more tows at a 3-4 mile range than you can do at a 20-30 mile range. So there's all kinds of nuances and complexities to this, which is why we wanted to do the study. We're still going to do the study. The question today will be whether the committee approves the $30 increase for the for statewide, because what we tried to solve was just a District 8 problem, which fell under where the rest of the state was. At any rate, yes, sir. If you could take a quick moment to introduce yourself.
I'm Zachary White, Operations Manager of Shanks Towing South in Richmond, Virginia. Our trucks cost $4 to go 7 miles. I support this bill.
Okay, thank you. Next.
Good afternoon, Chair and Committee. My name is Michael Croak. I am the owner of Shanks Towing South, based here in Richmond, Virginia. Obviously, payroll is going to be my largest expense. It always has been, always will be. There was a time when fuel was at a manageable cost. It is now my largest operating expense outside of payroll. I do support this bill, and I have brought a portion of the people I employ in this city with me.
Okay. Thank you very much.
Thank you.
Okay, next, if you just tell us if you have something new to offer, do that. Otherwise, just let us know who and where you're from and whether you support the bill.
I'm Ashley Miller from Dominion Towing. We are in Northern Virginia. We do support the bill for all the reasons previously mentioned, but also fuel is being talked about in the form of just in vehicles. It's used in other aspects as well. Fuel, if you look on your power bill, references fuel surcharges too. So it's even used in electricity, at least up in Dominion Power. So we do support this bill for all of the reasons. Thank you.
Thank you.
Thank you.
Hello, my name is Michael Fernandez. I'm owner of Battlefield Towing Storage in Northern Virginia. I've been in business for 27 years. I had this here to read to you, but to simplify this real quick, I have one checking account, and payroll, fuel, truck payments, everything gets paid out of it. So regardless of how you look at it, we do need an increase, especially in the fuel. But at the bottom end of the day, we do need an increase to support our industry and to keep high standards. And thank you. And I do support the bill 1649.
Thank you.
Thank you.
Next.
Heather Ferguson, owner of Dominion Towing in Northern Virginia. We support the bill due to the rising costs we've incurred over the past few years with not being able to have any extra charge coming our way. And like everybody else said, it's not just fuel. Yes, that's what it's categorized at, but the cost of business is highly inflated over the past few years, and we support it. Thank you.
Thank you.
Hi, my name is Gina. I work for Advanced Towing in Arlington, Virginia. I'm the girl you may have heard about in the hallway or in a news article yesterday with cancer. I'm not here for pity party. I'm just here to show you that we're real people that need real help. My life depends on it. If this bill doesn't pass, I can't afford health insurance. That means I was told by Arlington, well, there's always Obamacare. That's what Arlington told me when I begged for help. It's not that easy. I'll lose my doctors, my care. I'll lose everything. So please, please support this bill today.
Thank you.
Thank you.
Mr. Chairman, I should have went first. Okay. I know you see me walking the halls now. This is my 20th day down at session. I appreciate all the time and hospitality and every bit of conversation I've had with every single one of you. In 2016, Arlington County promised me that they would do a study. It's 2023. There's no study done. A friend of mine who worked in the office took another job with Amazon. On the way out the door, called me a fool to believe that they were ever going to do the study. Because if they did the study, it would give me the ammunition that I would need to come here to prove to you that the cost of the tow, especially in Arlington County, is well north of what's in code now, and is probably going to be north of what we were trying to do with your bill, Mr. Chairman. The story that she told about the fuel is true. That for 17 months ago, I got a fuel bill that was $10,000 more than the previous month. So I took that fuel bill along with my health insurance bill, and I took my employee with myself, the biggest mistake I ever made in my life, down to the county manager's office to say, hey, look, what are you going to do for me? I only get to charge $135 in Arlington while everybody else in Northern Virginia is charging $150. They keep me that low because of my fight that I started years ago because I was convinced to come down here and fight by a lovely senator, and I did so. I've been walking the halls down here for over a decade, fighting different fights, and if you hadn't have intervened and helped me, I wouldn't be here today. So I'm very grateful for that. But getting back to what our costs are, Arlington's never going to raise the fee for us to be there. But I would urge you to please don't hold an entire industry in the state, in our Commonwealth, for one man's fight with one locality in Northern Virginia that everybody always hears about. I'll be back next year, walking the halls, You see the tow guy coming, pain in the tail guy, here he comes again, but I've got no choice. I could walk away from towing and sell my land, and I'd probably be okay. But what about my employees, the people that have been coming down here? It's never been about me. It's always been about them. That's why I come here to fight. That's why I'm here today. I need this money to survive another year. We're below what Northern Virginia gets to charge in Arlington County, and that's the most expensive place in the state to do business. But I appreciate all the time. Thank you.
Thank you, Mr. O'Neill. All right. Anyone here to speak in opposition to the bill?
Mr. Chairman and members of the committee, my name is Alana Crennan and I represent Arlington County. We are opposed to this bill because there are no consumer protections and there's no financial transparency. I have a story to share about the history of towing in Arlington County and why we are here to discuss fees. Our towers in Arlington like to make what should be a local issue into a statewide issue. When they don't get the answer that they like from our county board, they come to the General Assembly hoping for a more sympathetic audience. Take, for example, the last time we tried to increase our fees. We asked them to show us the data. They sent us back multiple incomplete spreadsheets that don't tell the entire story. At the county board's direction, we wanted our local towing board to meet and to have a transparent conversation about fees and consumer protections. However, after seats on the towing board expired, we couldn't get a commitment from towers in our area to participate, leaving the board without a quorum for much of 2022. Our county board had to intervene to restructure our towing board, reducing a 7-member group to just 3 so that we could hold our meetings. The lack of participation and apathy for our local process has been to the detriment of our consumers. We have emphasized to the towers that clear financial justification must be provided to support a decision to increase the base tow fee, and to date, certain operators have been unwilling to submit quality financial information to us to make better decisions. Additionally, I want to clear up the assertion that we haven't raised fees. In 2021, we increased our night and weekend charge and our drop fee. Apologies, we switched it around. We lowered our drop fee, but we increased our night and weekend charge instead. So we flipped it, we lowered that fee, but ultimately we did increase the fees overall. So even though the base tow fee has remained at $135, we increased the ancillary fees. HB 1649 does not put trespass towing under the Virginia Consumer Protection Act. The VCPA is a critical way for consumers to get recourse against a tow company if, let's say, the following event occurs. There's illegal towing for a car for the wrong reason, recklessly performing the tow in an unsafe manner, failing to return personal belongings, towing without authority of the property owner, damaging the car in the tow. It also does not include any requirements for data transparency to determine appropriate fee increases. This data could include fuel costs contextualized with fleet size and towing mileage, vehicle maintenance costs, facility costs, personnel costs, and administrative overhead costs. Earlier today, we heard that it costs one person $4 of diesel to go 7 miles. The average tow in Arlington County is only about 10 miles. So that would suggest only a $6 fee for fuel on top of, which would mean, if you would think about it, that would be just a $6 increase.
Okay.
Finally, in summary, I would ask you to PBI this bill with a letter from the chairman to study consumer protections and fee increases over the next year. We want to be able to see and discuss the data as well as figure out the best way to put trespass towing under the Consumer Protection Act. This is a conversation that takes just more than a short session to ensure we get it right. Thank you.
Next.
Mr. Chairman, members of the committee, James Hutzer, Virginia Association of Counties, we oppose the bill.
Mr. Chairman, Victoria Horak. I'm an attorney at the Legal Aid Justice Center. We represent low-income tenants across Virginia, and we oppose the bill. I spoke to a woman the other day who lives in an apartment complex that was towing cars when they thought that there was something expired. Her car was towed 4 times within 1 month. So we oppose any situation where she would have to pay an additional surcharge of $30 4 times in 1 month. And she's now facing eviction because she had to use the money to get her car back instead of paying her rent. And so this really squeezes low-income residents who need their cars to continue to go to work, to continue to get their kids to childcare. We oppose the bill.
Okay.
Chair, question.
Yes.
Ma'am?
Senator Peake.
Yeah, I think I missed something. Why did she get her car towed 4 times in 1 month?
It's a really common practice among some landlords to, like, the minute like residential parking passes expire, to go around and say, like, we couldn't see yours, it's behind something. You know, a property manager has a complaint about a person, or it's like the car of a living
Mr.
aid.
Chair,
Senator Peake.
so you saying the property manager was called? Does the property manager get anything when the car gets towed?
You know, I actually couldn't answer that question. I don't know if they're getting.
They're
a
all
cut.
shaking their head behind. Yeah, they're all shaking their head.
No.
I mean, Mr. Chair.
Yes,
Did this
Senator Peake.
person see to get her parking pass updated or display it so that they could see it after the first one?
Oh, absolutely, absolutely, they do. I'm just saying.
And they just haven't 4 more. Oh,
Yeah,
never mind.
there
Thank
are
you,
many
Mr. Chair.
reasons people get their cars towed, but that increased cost is really significant.
Yeah, just one additional piece of, thank you very much. One additional piece of information, the raise that went into the overnight or late night and weekends, what percentage of tows, what was that increase, and what are the percentage of tows that are done during those hours?
So essentially, Senator, they gave me a decrease is what they did. They changed the drop fee from $25 to $10, and they added in a $5 after-hours fee, which would be a portion of, I would say, probably 50% of my tows for $5 extra dollars.
50%.
But the drop fee, which they took away from me from 25 to 10, we don't even charge it anymore because it's not worth sitting there and haggling over $10. I told my drivers to go find somebody else. And then another question, can I answer another question that somebody asked earlier?
Please go ahead.
Low-income housing, the lady was speaking about low-income housing. I tow for all the low-income housing in Arlington County. The managers and people that I work with, if they call me up and they say that there's people destitute, they can't pay, I cut them loose. We don't charge them at all. And it's part of my cost that nobody ever sees. There's nobody sitting on my front step waiting there to get their car out that they can't get. I cut cars loose all the time. I give them back to elderly. I give them back to ladies with babies. I'm a huge sucker for that. But at the end of the day, that mechanism is being taken away from me. Thank you, Senator.
Mr. Chair. Very, very
Mr.
good.
Chair, down here to the right.
I'm sorry, Senator Rouse.
Thank you, Mr. Chair. I just have a follow-up comment. And that's great that the gentleman who's a tow truck operator does that. But as someone who grew up in low-income housing, there have been, and someone who's actually, I don't want to say victim, but been subject to multiple cars being towed for the simple fact of your visitor's pass or your parking pass falls from the middle of your rearview mirror, or they don't necessarily see it in the back window. It does happen. It happens often. Or if you're late getting your registration, the tags on your license plate, if you're 1 day late, you happen to go to DMV the next day to go get your tags, you may be late because your car be gone in the next moment because they come around and say, oh, your tags was expired and it's gone.
Gotcha.
So, again, it does happen. I don't think the young lady was too far off when she gave her testimony.
There are any number of issues that need to be dealt with in this industry. I would put us at this point right now. We need a motion, and we are going to make a decision about Delegate Wyatt's bill. The study is going to be done. This is a one-year adjustment. The study is going to be done to try to get at all of these kinds of problems, everything that the members of the committee and witnesses have brought up. This is a very, very difficult, very difficult problem, but, I think, there's certainly has to be some sympathy for the industry in terms of what they're going through. So, Senator Cosgrove.
Mr. Chairman, question.
Let Senator
Senator Sproul.
Thank you. Mr. Chairman and members, I want you to stick to the issues. Every time there's a problem that in Plan District 8, I call it North Virginia, the first thing they say is North Virginia pays more than everybody else. Just suppose in Hampton Roads, the teachers say to us, we don't get the same pay as they pay the teachers in North Virginia. Why? Just turn it around. Just propose that the car you buy in Tidewater, that same car in North Virginia costs you $30,000 more. Why? I don't know. My son lives in North Virginia. My house is roughly around $325,000. His house in North Virginia is $1 million. His house in Tidewater will be up to $125,000. I don't know why. So I'm looking at the, I understand about the fuel situation. So I'm saying if we need money for the fuel, but then you're using the fuel to come up to give a raise, if you can use the fuel just to save my health insurance, I don't buy it. To a study, Mr. Chairman, I do agree that we have a study. But what really gets me is that you give them this for 1 year. Then if after that year and the study, if it don't turn out right, do you really believe that they will not come back down here and ask us, do not take that $30 away? Because you're going to put a sunset clause on and say it's just for 1 year. But what happened after that year, it doesn't pan out. Those of us who are here, we're going to say, we gave it to you for 1 year, and it didn't, the study didn't show whatever, then we're going to take it away. Do you think they're going to really do that? So I just don't, it just bothers me when my friends from North Virginia were saying that North Virginia, they move.
Okay. All right, let's wrap this up with Senator Cosgrove.
Mr. Chairman, I move to report the bill.
Okay, we have a motion to report the bill and a second. Clerk, would you open the roll?
Senator Favola? Senator.
Oh, did I get Survell correctly? Yes.
Ayes 8, no 6, abstentions 1.
Ayes 8, no 6, extension 1. We have the $30 increase, and we will still do the study and try to get at the larger problems here. Thank you very much, Delegate Wyatt.
Thank you, sir, for your time.
All right, let's move along here.
Thank you, Senator Martin.
Delegate Bloxham, what you got for us?
Thank you, Mr. Chairman. House Bill 2304.
Turn your attention to 2304, motorcycle rider safety training courses.
Yes, sir. It's really just updating the code, taking out like sidecars and motorcycles. Really don't have a course taught in that now. It also changes some of the lines in here, and it follows the Motorcycle Federation safety requirements through the whole code. But it also, unless we decide that that's not what we want to, it follows the Motorcycle Federation safety course. And that's pretty much all the bill does.
Just one question I had on the helmet thing. I didn't understand that piece of the bill.
The way it was is that you had to have a full three-quarter helmet. That's in the July or August, wearing that is extremely hot. So what we decided to do is just use whatever is legal on the highway that you could use.
Okay, thank you. That clarifies that. All right. Questions for the gentleman from
Yes, Mr. Chairman.
the committee? Senator Sproul.
So on a motorcycle, other than a helmet, what else is legal that you can, what other can you, what is legal?
Are you talking about on helmets?
Yes, sir.
Okay.
Mr. Chairman.
Whatever's legal on the highway is what you can use using the driver safety course. That's all. This bill has to deal with the safety course taught.
Thank you. I got it.
Is all that is. So anything that's legal.
I'm good. Keep quiet. I'm good.
All right. Other questions from the committee? Oh, well, let's just make sure we check with the audience here. Anyone here to speak in favor of the bill? Anybody here to speak? Oh, in favor? Please.
Mr. Chairman, Matt Danielson with the Virginia Coalition of Motorcyclists. We'd like to thank Delegate Bloxham for bringing this bill. What this legislation does is what the current code has done is it's actually become more restrictive than the curriculum that Virginia actually uses to teach the course. And what this bill does is it brings the statute in line with the curriculum that DMV is already using, and we support it.
Well, that makes sense. Anyone else here to speak in opposition to the bill? I believe we had a motion.
Move to report.
Move to report and a second. Second. All in favor? Vote aye on the board.
Thank you, Mr.
Ayes
Chairman.
15, no zero.
Ayes 15, no zero. Okay, the House is back on a roll here. All right. Next, we have Delegate Delaney.
I gotta be across the street from you, Madam President.
Good afternoon, Mr. Chair, members of the committee.
Good afternoon. What you got for us?
I've got Senate Bill, I've got House Bill 2204, which is very much like Senate Bill 1398 by Senator Survell. This was a crime commission bill. It requires the DMV to annually collect existing DUI-related data and publish a report. It's necessary because there is a variety of DUI-related data currently available in Virginia. However, no comprehensive report that combines this data into one source. And I will say to the committee that there was some evolution on this in kind of technical form that resulted in a substitute before my bill came before the Courts of Justice Committee, and I did confirm with Senator Survell that he will be accepting the House amendments because that gets us to where we would like this crime commission bill to be.
That is my understanding, is that by accepting your bill, the way Senator Survell's bill is treated, they would now be identical.
Yes, Mr. Chair.
There we go. Questions from the committee? Is there anyone in the audience wishing to speak in favor of the bill? Anyone wishing to speak in opposition? We have a motion to report. Do we have a second?
Second.
I have a motion and a second to report. Would you open the roll, please?
Ayes 15, no zero.
Ayes 15, no zero. You're out of here.
Thank you,
Good
Mr.
job.
Chair.
Thank you.
Committee.
Next, we have Delegate Adams. Delegate Adams here? This is the conforming
Yes,
bill?
sir. Mr. Chairman.
Could I have a motion from, on this from Senator Newman?
Mr. Chairman, I move that we conform House Bill 2302 to my TPOP bill.
Second.
I have a motion and a second to conform this to Senator Newman's bill, and I assume this will go to conference. Very good. Any questions from the committee?
Second motion, you need to.
Yeah, I think we're,
Adopt the sub. We're adopting the sub.
okay, so we would be adopting the motion here is to adopt the substitute. All in favor, say aye.
Aye.
Opposed, no.
Second.
And does that need to go to finance?
Yes.
So the motion is moved to report and re-refer to finance?
I think I have a letter here. Hold on, see if this applies to it. Is this Senate Bill 2302? Yes, it is. So it does go to finance. All right. So we have an amended motion to report and refer to finance. Would you open the roll, please?
Ayes 15, no zero.
Ayes 15, no zero. Delegate Adams wins in absentia. Okay. Next, we have Delegate Simons. Okay, I just have a list here of people that signed up. Delegate Simons does not appear to be here. And, all right, Delegate Wiley, come on up here and present your bill.
Good afternoon, Mr. Chairman, members of the committee. House Bill 1437 is in front of you. This authorizes the Commonwealth Transportation Board to permit the placement of law enforcement devices in VDOT right-of-way. In addition to authorizing the placement of these devices at VDOT right-of-way, House Bill 1437 contains provisions limiting which these devices will be used for, such as active felony investigations, Amber Alerts, and Silver Alerts. Furthermore, the provisions of this bill provide strict limitations on the data and its usage while also creating a penalty for its misuse. This legislation has been endorsed by a wide range of stakeholders, including the Virginia Sheriff's Association, Virginia State Police, Association of Chiefs of Police in Chesterfield County. In summary, House Bill 1437 authorizes VDOT to provide permits for law enforcement devices at VDOT right-of-way while also establishing guardrails for the data, which currently do not exist. I request this bill conform to SB 1165, which reported out 12-1.
Okay.
In your committee.
So,
Be happy to answer any questions.
so should we move the substitute here? Moved and seconded on the substitute. All in favor, say aye.
Aye.
Opposed? Thank you. All right. And my understanding is, Delegate Wyatt, is that VDOT needs this to be able to permit these things. They need this legislation to do that. Is
Yes,
that
sir.
correct?
Currently, and which the court has authorized early on, Supreme Court has approved.
Now, currently, 30 days is as long as you're able to do this, and that the machines basically time out and automatically, the server automatically removes something after 30 days.
The way this legislation works is it's up to 30 days, and yes, sir, it will be timed out in terms of data retention.
Okay, but if somebody wants to do something less than 30 days, that is their option too, is that correct? I believe that's what I was told.
I think the
by
current legislation is the state police have it at 24 hours they're allowed to retain it.
Yeah.
And we're extending it out to 30.
That's what I'm understanding.
Which I think is.
Mr. Skiles, you have some.
Good afternoon, Mr. Chairman, members of the committee. David Skiles for the Vector Corporation representing Flock Safety. To your question, Mr. Chair, this legislation requires that the data be deleted after 30 days unless it's being used in an active law enforcement investigation. I do want to be clear that we are talking about the use of or the retention of data for stationary license plate readers, not the mobile devices, since there seems to be some confusion about that. But this statute would require that data be deleted after 30 days. It's also worth noting that that is the shortest retention time period in the code. If we go and look at 46.2.882.1, which is photo enforcement of school zones and work zones, the data retention period for that the General Assembly authorized in 2020 is 60 days. So this is half the amount of time.
Okay, so to kill two birds with one stone, you're in favor of the bill?
You got it.
Okay, thank you.
Mr. Chair, I have a question.
Okay, let's get, I think, Senator Peake.
Yeah. Mr. Chair, first, so this is stationary, correct?
Mr. Chairman, Senator Peake, that is correct.
I did, Mr. Chair, patron or witness. I've had people talk to me with concerns that these are going to be sitting there reading at all times. So these are going to be stationary, placed in the right-of-way, reading everybody's license plates at all times. My understanding, and am I correct, that are they just turned on when there's an actual felony investigation for an Amber Alert or felony crime? Or so explain that to me.
Certainly, Mr. Chairman and Senator Peake, taking a step back, in 2020, the Supreme Court ruled in Fairfax County Police Department versus Neal that the passive collection of license plate data was legal and constitutional. So the way in which, or the simplest explanation in which the way these devices work is the devices will continue to collect data. That data is stored. If there is a pop on the system from the Federal Bureau of Investigation's NCIC crime data, that would notify law enforcement officers in that area. And after 30 days, all that data is deleted, except for any that might be being used for an active law enforcement investigation. Importantly, that data is stored, but is only accessible by the law enforcement agency for which there is a contract with the vendor. Does that answer your question, sir?
There we go.
I'm not sure, Mr. Chair. Follow up then.
Follow up.
So am I correct then? You authorize this, CTB authorizes it, you put this stationary license plate reader in the median, and it's reading all day, every day, 24 hours a day.
Mr. Chairman and Senator Peake, yes, that is correct. I would follow up by saying that it's important to understand that these devices can already be used in areas that are not VDOT right-of-way. So, for example, in a city or a town that has control of their own right-of-way, they're able to use these devices unrestricted. Furthermore, there are cases of where law enforcement are putting these adjacent to VDOT right-of-way. There's no guardrails currently in place, and so what we're trying to do with this legislation is put some uniformity and some parameters around how these devices can be used.
Mr. Chair.
Okay, thank you. Senator McClellan.
I have a few questions. I'm not sure if they're for the patron or who exactly. So one of the concerns that I have around this bill is guardrails for making sure that this information is in fact not misused. What are the consequences for misusing it, and who is going to monitor and administer that? So as I understand it, is it state police or local law enforcement that is placing these cameras in the VDOT right away?
So, Mr. Chairman and Senator McClellan, yes. So the way in which this bill is structured, a law enforcement agency, either the state police or a local law enforcement agency, would contract with a private vendor. I'll pause there and say that is identical to the type of relationship that this General Assembly authorized in 2020 with photo enforcement in school zones or work zones. And the contractual relationship between the private and public entity is basically the same. The issue here gets to how do these devices get placed in the VDOT right-of-way, and that would have to be permitted through VDOT. With respect to the misuse, this legislation copies word for word Section 46.2882.1, where there would be a $1,000 civil penalty for the misuse of data. And that would be, because it's written in with Virginia Department of Transportation, they would be the ones to levy that civil penalty.
So, follow up, Mr. Chair.
Senator McClellan.
So what agency would determine whether there was an active felony investigation, and that all of the parameters around which this data can be used have in fact been met? Would that be VDOT, or would that be state police? Like,
when we talk about the use of the data for an active felony investigation?
So this is basically saying that the devices can be used for law enforcement purposes, which means an active felony investigation, an effort to prevent a targeted act of violence, or an Amber Alert. My question is, who will make the determination? Let's say, for example, City of Richmond decides, well, I mean, it's not really VDOT right away in the city. So Chesterfield County, it's a misdemeanor investigation, or it is, it's not actually a felony investigation. Who will be the one to determine, yes, you put this in the right of way for one of the authorized purposes under this bill, or no, you didn't? So which agency has oversight? That's not clear in this bill.
So, Mr. Chairman and Senator McClellan, I got my law degree from the Richmond Times-Dispatch, but I would submit that if you were using this data for something other than an active felony investigation, that would be inadmissible in court, since it's only active felony investigations that have been authorized. But when we talk about subsection F, which is the misuse of the data that's being collected, what we're really trying to get at there, and again borrowing this language directly from the Photo Enforcement and School Zone statute, that's about data that would be disclosed, or that the data would be somehow mishandled or misused, and that would be enforced through VDOT. Again, exactly the same as it is in the Photo Enforcement and School Zone section of the code.
Senator McClellan.
I think I would have more comfort if this bill went through the judiciary, because here's what I'm getting at. You are now expanding the use of these machines to collect data that are going to capture more data than just the subject of the investigation. So you've got a larger, an even broader civil liberties issue. If this were a subpoena, you would go to court and say, this is what I'm going to use this for, but I don't see those guidelines around this. This seems to leave it to the law enforcement agency
I don't have this as a...
to use this data when they want, without any guardrails around, are you going outside of the scope for which you're authorized to do it? So I say all of that to say I would be more comfortable if this bill went through courts and not here, so that some of our lawyers can get around, are we fully protecting civil liberties here when we're expanding the universe of what's going to be captured by these cameras?
Thank you, Senator McClellan. Is there
I think maybe Senator Obenshain.
Senator Obenshain.
Mr. Chairman, let me ask a couple of questions and see if I can help, because I had some confusion about this too. Now, my understanding is that these devices, they capture essentially snapshots of data. It's not a continuous image that is running. So when I go by, it captures a snapshot or data related to my vehicle, correct?
Mr. Chairman, Senator Obenshain, that's correct.
And when you are in a different vehicle traveling the same road and go by, that's a different piece of data, right?
Mr. Chairman, Senator Obenshain, that is correct.
So if there is a felony investigation that involves my license plate it will flag that piece of data from this device located on 288 or wherever in Chesterfield County, correct?
Mr. Chairman, Senator Rubenstein, that is correct.
And at the end of the 30 days, everything that hasn't been flagged in connection with an ongoing felony investigation or other purpose listed in this statute is statutorily required to be deleted from the database and destroyed, correct?
Mr. Chairman, Senator Rubenstein, that is correct.
So the only thing that remains is my piece of data because, and as long as there is an ongoing or active criminal investigation, but the vast majority of the data collected during that previous 30 days is able to be deleted without interfering with that one ongoing criminal investigation, and it's all gone. Is that right?
Mr. Chairman, Senator Rubenstein, that is correct.
Okay. And that helped me.
Okay, just very quickly, if we could get Major Maxey just to make any comments here, and then we do need to conform this to Senator Lewis's bill.
Yes, sir, Mr. Chairman. Ron Maxey, Virginia State Police. As was mentioned earlier, these devices currently are in use. There are no guardrails in place at this point. The guardrails put forth in this for the stationary devices will not put guardrails in place for the mobile devices. We have them on our cars. Currently, we need this legislation to state police or we will lose our license plate reader program. We have 81 devices around the state within the VDOT right-of-way, approximately $2.3 million invested in that. So absent a bill, that program is gone. Mr. Skiles was correct that this data is being captured. A license plate or a vehicle make would be put on what we call a hot list that would be queried against this data. This data is not being searched for anything other than if a tag is needed and we need to run a query against this. At the end of this, the system would be set up to 30 days, it would purge. Currently, these devices are being used around the Commonwealth. We purge our data based on some guidance provided in previous years by the AG's office. Some localities hold this data indefinitely. They keep it as long as they feel necessary. So there are no guidelines at this point in that data.
Mr. Chair.
Senator McClellan.
Question though, but right now, who, in my mind, this is the difference. And if I'm wrong, please let me know. Okay. Here you're contracting with a private vendor and they're collecting the data for your use. For the cameras that you have now and your dashboard cameras, that's you. That's not a private vendor, right? That's the law enforcement agency.
Mr. Chairman, Senator McClellan, we do have mobile license plate readers on our vehicles. You've probably seen them. Third-party civilian vendors use them all the time in the city of Richmond. Okay. They're mounted on the vehicle. That's what they are. They are mobile license plate readers. These are simply ones that are mounted permanently within the VDOT right-of-way. They do the same thing. This is just seeking to allow them to be placed within the right-of-way. And based on the fact that we do understand there were some concerns about this type of device being used in captured data, we tried to put some guardrails. We tried to work with various stakeholders because at this point, you can ask agencies across the Commonwealth and they will probably all give you different data retention periods, what they use the data for. So this gets you within a guideline where it provides guidance for all of us to be consistent.
Okay. Senator McClellan, we need to conform this to Senator Lewis's bill by taking the substitute. Do we have another query?
I have a question, Mr. Chair.
Hold on. Did Senator Suderline, did you?
Yeah, just briefly. It's frustrating to me that each time there's a surveillance expansion, it's brought forward. Those of us that have concerns about it suggest that there's not enough guardrails on it. And then the next time we hear that we need to have guardrails on it, it's because there's going to be a further expansion of a surveillance program here in the Commonwealth. And it's the same thing, we experienced this exact same thing on facial recognition, and we've been experiencing this on license plate readers over the last decade. And that's very frustrating to me to hear from the advocates of these programs each time that they really want the guardrails now when it's also expanding the programs yet again. So thank you, Mr. Chairman.
Thank you, Senator Rouse, and then let's wrap this up because we just need to get this.
Thank you, Mr. Chair. Mike, and I'm still not clear, I would feel more comfortable with this in judiciary because of the data collected. I understand that there are mobile units. The local government can retain all this information at the local level. I understand these are stationary license readers as well, but there's a third party who's contracted out for these stationaries license readers. Is that the case, Mr. Chair?
Mr. Chairman, Senator Rouse, I'm happy to maybe answer that question. I think what is missing in all this is most of this bill that is before you, 75% of it, is borrowed from existing code sections with existing contractual relationships between private vendors. In fact, the General Assembly acted on a bill brought before the General Assembly this year from the Senator from Hampton that talked about private contracts with vendors such as the ones that operate license plate readers, and that was for something dealing with the Hampton Roads Bridge Tunnel. But the point remains that most of this bill is borrowing from other code sections. The relationship between a third-party private vendor and a law enforcement agency is to deploy that equipment. It is not dissimilar to the relationship between law enforcement and a body-worn camera company. It is not dissimilar to the relationship between a law enforcement agency and a company that operates photo enforcement equipment. And so we're having a discussion about the data and the data that's collected, and we're borrowing from code sections that have already been...
But the difference is body-worn cameras, Mr. Chair, a further question.
I don't believe this is about, well, go ahead.
It's about data collection for me, Mr. Chair, so I get a good understanding of it. Body-worn cameras on the officers, those are collected and stored at the local level, and the only one that will have access to that data will be the chief of police. I know this because we just outfitted our entire police force with body-worn cameras, and we had to actually increase our capacity, which is through a third party, to retain that data. There's no selling of that data, and we understand who exactly we're contracting with. My concern, or my understanding, at least I'm trying to understand it, because I don't necessarily oppose the bill, I just want to understand it more, is the data collected, like these things run all day. We're contracted out to a third party. In the bill, it states that there would be a $1,000 fine if the data is misused. Who enforces that, and who's in charge of that? Agency's in charge of watching over that data is what my concern is. So I just don't understand that part of it.
Yep,
Mr.
Chair.
Okay, thank you. Was your question answered?
It was not. He was in the middle of answering.
Yeah, Mr. Chair and Senator Rouse, excellent question. Again, I'm a little familiar with the Virginia Beach body-worn camera program because I might represent the company that outfitted them. And the relationship is exactly the same, where those body-worn cameras, that data is stored by a third party and then shared with a Commonwealth's attorney and a defense attorney when there's a use in an investigation. So the relationship is not dissimilar in terms of the storage. And much like in this case, a private vendor has that data. It is being stored in an encrypted format. In this case, it's using a server and an encryption service that the Department of Defense uses for its data. And after 30 days, as Senator Obenshain noted, it is automatically deleted unless, of course, there's a piece of data that's needed for an active law enforcement investigation. As it relates to your question about the civil penalty, and I might have misunderstood, but it was pointed out by Representative VDOT that would probably be through a court, not through VDOT in terms of levying the civil penalty. But I won't put words in her mouth. So that addresses hope that addresses your question.
Okay, here we go. We got Senator McClellan. We need to adopt the substitute and conform this, but Senator McClellan, I believe, has an amendment to the substitute. So let's get the substitute before us, which is the bill as it came out of here with Senator Lewis. And so should we, I guess, should adopt the substitute first and then amend it? Okay. So do I have a motion to adopt the substitute?
So moved.
Second.
We have a motion and a second. All in favor, say aye. Aye. Those opposed? Okay, Senator McClellan, your amendment.
Mr. Chair, I would move we add an enactment clause that would direct, I guess, VDOT to convene a working group with the Department of Criminal Justice Services and the state police and anybody else they want to add to make recommendations for making sure we have all the correct guardrails, and DLS can figure out a better way to say that, including identifying what agency is responsible for enforcement for all of the reader technology. Because I share Senator Sutherland's concern, and I hear you saying that you pulled this directly from other code sections, but that doesn't mean that we got the guardrails right there either. And I think if we can get some guidance next session that says, having looked at all of these types of technologies, here are the recommendations we make for making sure that we are protecting, the civil liberties of the people whose data is getting collected, particularly when third-party vendors are involved. So that is my motion.
Members of the committee, is that understood in concept?
Yes, I'll second.
Okay.
Yes.
All right.
No, Mr. Chairman.
Yes, Senator Cosgrove.
Mr. Chairman, thank you. Now, I think we're throwing a little more mud in this water because we've already passed Senator Lewis's bill. It's already passed out of the Senate. So now we're amending this bill after we conformed it to Senator Lewis's bill.
Well, Mr.
So
Chair,
where do we go from there?
Mr. Chair, it's not in conflict. So by adding an enactment clause to this bill, directing that working group, but still allowing the rest of the bill to be enacted identical to his, it's not in conflict. It just has an added enactment clause directing that working group. So
Right.
both
I
bills
guess where I'm going with this, Delegate Wiley, is you might want to take it, when it comes to the floor, you need to explain the differences.
Okay.
You're going to have to accept our substitute or reject it.
Mr. Chair, and Senator McClellan, if I might just ask one thing. I would caution that this bill is really focused on the permitting and citing of stationary devices. And I would only raise the concern that when we start talking about mobile units, we're really getting outside the four corners of what this bill was intended to address. And so I certainly understand and perhaps could find myself in agreement that a work group makes sense, but I would caution that maybe not including mobile devices, since that's pretty far outside the scope of what this bill is.
Well, is that one of the code sections that you pulled language almost identical from, that you referenced here?
Mr. Chairman and Senator McClellan, no. The code sections that we pulled from were the photo enforcement section that this General Assembly that authorized in 2020. And I believe, and Emma might be able to reference, I think that was the only section.
And Senator McClellan, you're saying remove that?
No, I'm saying whatever code sections you cribbed from, include those technologies in what the working group studies. And Joanne is nodding. I think she understands what I'm saying.
And would you like a report back?
Senator
Thank you, Mr. Chairman. Would you
and a report back to the chairs of the transportation committees by December 1st.
Or 2023.
Are we comfortable with the concept? So do we have a motion on Senator McClellan's amendment to the substitute?
So moved.
We have a motion and a second. All in favor, say aye.
Aye.
Opposed? No? I believe the ayes have it. We will add that to the bill, and at this point in time, they are conformed. Can we have a motion to report?
So moved, but Mr. Chairman, we would report the substitute as amended.
We have a motion, and we have a second? Second. We have a motion and a second to report the substitute as amended by Senator McClellan. Let's vote on the board.
You've got
Senator. Ayes 11, noes 3, abstentions 1.
Ayes 11, noes 3, abstentions 1. Thank you for your time, gentlemen. All right, we have 3 more to go. We got Delegate Simons, and then Delegate Carr, and then Delegate Sewell. Delegate Simons, what you got for us?
In a nutshell, I have a school bus, HB 1723, that allows localities to keep issuing traffic tickets to drivers who pass a school bus when its lights are flashing. It was brought to me by the City of Newport News. It clarifies the code that a bus stopped with at least one warning device activated is prima facie evidence that the bus was stopped for the purpose of letting children on and off the bus. And I have more backstory information if you would like it.
I think it's fairly clear what you're attempting to do here. In other words, as long as you've got one of the approved devices to let you know that there's a school bus stopped, that's enough evidence to issue a ticket based on either visual or camera observation?
Yes, this came to us because a judge felt the law wasn't clear that the bus stop arm camera evidence wasn't enough, that they actually had to have additional evidence that kids were getting on and off the bus at the time.
Okay, and that is often, if a driver has to see children, a lot of children don't go across in front of the bus, they get off on the side. You absolutely can't see it from, so. I've got it. Any questions from the committee?
Yeah, Mr. Chairman.
Senator Cosgrove.
Delegate, I'm looking at both the impact statement and the text in the bill. When does a school bus carry elderly people?
I also saw that. I think maybe special events, sometimes the buses can be used by other groups. But I do have representatives from Newport News Public Schools if you'd like me to have them come up.
Mr. Chairman.
Could be a chaperone.
May we hear from Newport News?
Please, yes.
Okay.
Come before.
Yes, Senator Marsden, Senator Cosgrove. It's my understanding that there are times when buses are used to transport people from, for example, we have an area downtown that floods quite often, and we will send school buses down there to actually transport them. Sometimes they are elderly people, not all the time, but I think that's probably one of the things that may be in play there. Thank you.
All right, thank you.
All right. Any other questions from the committee? Anyone in the audience wish to speak in favor of the bill?
I have a question.
Thank you.
Good afternoon, Mr. Chairman. I'm Jerry Wilson with the City of Newport News, and we support the bill.
Okay, Newport News is in.
And again, Patrick Finner, Newport News Public Schools, and we also support the bill. Thank you.
Okay. Anyone else here to speak in opposition? All right, we move by motion.
Mr. Chairman, I move that we report the bill.
We have a motion and a second to report the bill. Would you open the roll, please?
Ayes 14, no zero, abstentions 1.
Ayes 14, no zeros, abstention 1. Thank you, Delegate Simons. Next, Delegate Carr.
Thank you, Mr. Chairman. Before you is HB 1745. Mr. Chairman, members of the committee, HB 1745 is a consumer protection and public safety bill, which adds to the prohibited acts for tow truck drivers and towing and recovery operators. Localities often have a contract or a predetermined rotation for law enforcement requested tows and are capped in the prices they charge. Other towing operators who are not included in this contract and are not capped in their price often race recklessly to rabbit scenes before the contracted tow truck does. This bill will prevent non-contracted tow truck drivers whose prices are not capped from taking advantage of vulnerable stranded drivers. Appreciate your consideration of the bill, and I believe there's some folks here to testify.
Okay, thank you very much. Anyone on the committee have a question for Delegate Carr? Is there anyone in the audience wishing to speak in favor of the bill?
Mr. Chairman, my name is Melvin Lawson. I'm the Director of Operations for Cybert's Towing here in Richmond. Also represent VATRO, the Virginia Association of Towing and Recovery Operators. VATRO stands behind this bill. We as police towers, we are limited in what we can charge. We are called out when the police call us. Right now there's an app on my phone I can show you that I can track what's going on with the Department of Emergency Communications here in Richmond. I can tell you when an accident is happening in a certain part of town. I can race to get there. If I'm the first one on the scene, I got a good chance of getting it, and I can charge whatever I want to. We're behind this bill.
This is butting in line, basically, is
Yes,
what
sir.
it is, and charging more for the privilege.
Yes, sir.
All right, thank you very much.
Mr. Chairman?
Senator Sproul.
Two questions. To the best.
Go ahead, sir.
How much more you want to charge? How much more, you know?
Mr. Chairman, this is not about charging any more. This is allowing police towers to charge what the contracted rates are at their locality.
Okay.
We're not asking for an increase in any.
Thank you. Mr. Chairman, second question.
Senator Sproul.
Delegate Carl, are you on the committee across the street?
Yes, sir, I am.
Across the hall?
Yes, sir.
Did you just vote on the bill a while ago? Thank you.
All right. Senator Cosgrove.
Thank you. Delegate, question for you. It seems like a simple question, but I'd really love to hear the answer. Actually, two questions. First off, how are you going to know if somebody's listened to a police radio or not?
Mr. Chairman, it's not that you know, it's you're getting into intent, but most of the times in these situations, there is a police officer on scene. A disabled vehicle accidents, most often law enforcement is there. This allows them to control the process and kind of control what takes place.
And the second question, Mr.
Senator
Chairman.
Cosgrove.
Actually, this does more than just listen to. This also prohibits driving by and initiating contact. So it's important the committee know that. But I guess, and I'm also looking at the body of the bill. I need to defer to a legal mind someplace. What's the penalty? What's the enforcement?
The enforcement of 46.2118 is actually through the Attorney General's office.
But what's a penalty?
Right now, there is no penalty laid out in that statute. It's consumer complaints. The Attorney General's could, if it was egregious, they could sue in court. It's my understanding.
Mr. Chairman?
Senator Favola.
I would like an interpretation from General Counsel. I guess on, so item number 8, which is a prohibited action from the tow truck driver, according to this legislation, I guess it would be intentionally drive by the scene of a wrecked or disabled vehicle that is subject to a law enforcement request rather than just drive by. I think I may like the word intentionally added, if that would help.
Mr. Chairman, Senator, it would be driving by and initiating
I'm sorry, it would be.
contact. It would be driving by and initiating contact.
Okay, driving by and initiating contact. So you think that's enough protection? Saying intentionally before driving is not. Wouldn't that add some clarity?
Mr. Chairman, Senator, that would be up to the committee.
Well, then
Hold on one second. Senator Favola, could you repeat that, please?
I would feel more comfortable offering an amendment that just placed the word intentionally before drive on item 8.
I'd second that.
And it's meant to be a friendly amendment.
Okay. Delegate Carr, you
It is a friendly
good? Senator Cosgrove, we have a committee amendment before us. Could you just state your understanding of it, counsel?
Mr. Chairman, the amendment on, this would be on line 28, would add right after 8, intentionally, and then drive by the scene of a wrecked or disabled vehicle that is subject to law enforcement, requested tow, initiate contacts, et cetera.
Okay. All right. All those in favor of the amendment from Senator Favola, say aye.
Aye.
Opposed? So we have the bill before us as amended. Anyone in opposition to the bill?
Mr. Chairman, I would move that we report the bill as amended.
Report the bill as amended. Major Maxey, did you have anything you wanted to add?
Mr. Chairman, Ron Maxey, State Police. State Police has no position. I was just going to try to catch the delegates' attention. The addition of intentionally is going to make this, in my opinion, an unenforceable bill because due to the fact that we would have to prove the intent. I just wanted to point that out to her before she accepted that. So again, we have no position, but it will make this a bill that unless the person tells us that is what they intended to do, we will never be able to prove intent in court if that's a part of this legislation.
Senator Favola,
It wouldn't be a part
based
of
on that
legislation
information,
anyway.
would you
If somebody
like to reconsider?
Go ahead.
I was just going to say that the thing comes, if he wants to tell about his, yeah.
I mean,
you know, he can tell about an instance where somebody came and, you know, if you have somebody over the, you know, somebody gets there before the contracted tour gets there.
Right.
They get there and they say, yeah, I'll tell you, yeah, it's just 250, whereas their charge is limited 150. You don't know the difference. And they don't know that, who's going to know that they were listening to the phone.
Right. No, well, and the language does say and initiate contact, so maybe that is enough protection. I don't know. Based on it does have that initiate contact in there. So, but you still think it's unenforceable, and I will be willing to withdraw my amendment.
Again, I hate to do any harm to this, Ron Maxey. Mr. Chairman, just the addition of that would require law enforcement to prove the intent,
Right,
not
which
the
you
action.
might be able to do, yeah. Okay.
It just makes difficulty. Again, I was just trying to catch your attention just to mention that as we were going
Okay,
through.
well, Mr. Chairman, I withdraw my amendment.
Okay, the amendment is withdrawn. The bill's before us. Do we have a motion?
Yeah,
We have
Mr.
to
Chairman, having voted on the prevailing side where we amended the bill, I move to reconsider that vote.
Second, we have a motion to reconsider the vote and a second. All in favor, say aye.
Aye.
Or put your,
yeah.
on the board. That's a rule change. Hold on, excuse me. There we go.
Ayes 14, no zero.
Ayes 14, no zero. We're reconsidering. All in favor of, with a recommendation that we vote no, Senator Favola's motion is before us. All in favor, say aye. All opposed, no. No. Okay, the motion is withdrawn.
Yeah.
Bill's before us.
Move to report.
We have a second. All in favor, record your vote.
Mr. Chairman, if I might, Delegate, the only reason
Ayes 11, noes 3.
The only reason I put up the no votes is because basically I just don't see how this is possibly going to be enforced. How do you, keep somebody from listening to the radio? That's no malicious intent in their votes, okay?
Thank you. Thank you, Mr. Chairman, member of the committee.
Fall out of favor of the state police to be called.
Yeah.
Yeah, so. Very good.
Thank you. Thank you, Mr. Chairman.
Is Delegate Sewell here? I am. Is Delegate Sewell? There she is. Okay. All right.
Good afternoon. Thank you, Mr. Chair. Mr. Chair, members of the committee, each year the Northern Virginia Transportation Authority, the Northern Virginia Commonwealth Transportation Board conducts an annual joint public meeting in partnership with the Virginia Transportation Commission and the Virginia Railway Express. And with this piece of legislation, it affords us the opportunity to include the National Capital Region Transportation Planning Board in that joint annual meeting where they will discuss all transportation projects that are under the consideration by each entity located within Planning District 8. So therefore, in addition, this legislation also affords for those meetings to be conducted in a virtual component and capacity to ensure greater access and transparency for transportation projects throughout the region.
Okay, so this is, you're invited, you don't have to come, but one of the members of the board from Virginia.
Virginia representative, yes, that was a friendly amendment from my colleagues in the House.
Okay, very good. Senator Cosgrove.
I would like Senator Favola to make a motion since she's the only one here that lives in Planning District 8. Oh, I'm sorry, you do too. Never mind.
I think it's a fine bill, so I'm going to move to report it. Okay.
We have a motion and a second to report. All in favor? Report your votes.
Thank you, Mr. Chairman and member of that National Capital Transportation Planning Board.
Ayes 14, no zero.
Ayes 14, no zero. The bill reports. Folks, thank you very much for a wonderful committee and staff. Thank you for all your hard work and volunteers who are here helping out. We appreciate it greatly, and we'll see you next year.